Good evening, everyone. My name is Virginia Harger. I'm the chairperson of the Shelton Planning and Zoning Commission. Today is Wednesday, August 28th, 2024, and the special meeting of the commission being conducted in Shelton City Hall via Zoom is hereby called to order at 6:03 p.m. This meeting is also being carried live on YouTube. Would everyone please rise for the Pledge of Allegiance? I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. I'll start off with a roll call of the commission. Please verbally indicate you are present when your name is called. Commissioner Kelly?
Present.
Commissioner Parkins? Present. Commissioner Cristiano?
Present.
Commissioner Tiki?
Present.
Commissioner Motto? Here. Alternate Commissioner McGee?
Present.
Myself, Commissioner Harger, Ms. Castro, our Assistant P&Z Administrator.
Present.
Ms. Renarsos, our Recording Secretary.
Present.
And Ms. Charbonneau, our Stenographer.
Present.
A couple of points before continuing with this evening's agenda. Ms. Castro will act as a Zoom meeting host. While commissioners will be able to make comments throughout the meeting, the chair asks that you please identify yourself and wait to be recognized by the chair before speaking to make sure we are not all speaking over each other and to make sure our recording secretary is clear as to who is speaking. I would appreciate if the members of the audience could be a little bit quieter. Thank you. 2 public hearings are on this evening's agenda, and I would like to share the protocol we will be following. Ms. Castro will indicate if any written comments were received from members of the public no later than 24 hours prior to the start of this evening's meeting. Written comments were received, they will be read into the record. The applicant and or its associates will make their presentation. The commission can ask questions during the presentation or at its conclusion. The applicant and or associates can answer commissioner questions at the time they are presented or at the conclusion of the presentation. At the point in each public hearing when the chair asks for public comments, we will begin with elected officials of the city present in the auditorium, followed by elected officials participating via Zoom or through a phone link. After elected officials conclude their comments, members of the public will be recognized, starting with those present in the auditorium, followed by those participating remotely via Zoom or through the phone link. Those in the auditorium will need to list their name on a sign-up sheet, and those sign-up sheets will appear on a table. Those participating via Zoom will need to use Zoom's raise your hand feature, and those participating via phone will be recognized after dialing *9. After you are recognized, please state and spell your name and state your address to assist the recording secretary and stenographer when doing the minutes and transcript of the meeting, of the public hearing. Each speaker has 5 minutes to present comments, which should address specific criteria of the zoning regulations, merits of the application, and be new information, not a repeat of comments previously presented. Comments and questions should be directed to the commission, not to the applicant and its associates. Members of the public are expected to practice appropriate etiquette by being quiet, observant, and respectful. Disruptive attendees may be removed from verbally participating. The applicant's attorney and or associates will be given the opportunity to address any comments or questions from the public after the last person from the public has been given the opportunity to speak. If the commission feels further information is needed from the applicant, the chair will ask for a motion to continue the public hearing. If a public hearing does remain open, the commission is not allowed to make any public comment, discuss any part of the applicant's and or his associate's presentation, or receive any additional information from anyone. The commission feels the applicant and or his associates have answered all questions and have addressed all concerns from the commission and or public. The chair will ask for a motion to close the public hearing. And the commission reserves the right to discuss an application at the close of a public hearing or to schedule a discussion at an upcoming commission meeting. At either time, the commission will be asked by the chair on how it wants to proceed. So the first public hearing is for application 2416 Dominic Thomas for Daybreak Ridge and for a text amendment. And Commissioner Motto, would you please read the public hearing notice?
Initiation of application 24-16 Dominic Thomas for Daybreak Ridge LLC for text amendment to SPZC regulations, section 34.1 under Planned Development Districts regarding applications for affordable housing under Connecticut General Statute 830G.
Thank you. This application was accepted for review on July 10th and posted to the city's website prior to the opening of this evening's public hearing. Was the application for a text amendment and a copy of the decision in 121 Beach Road LLC versus the Planning and Zoning Commission of the Town of Fairfield. Ms. Castro, any other reports, materials, or correspondence received within the time period for this application but not yet posted to the city's website that we need to acknowledge for the record?
No.
Okay. And I can see the applicant is present, Attorney Thomas. Would you please identify yourself for the record and proceed?
Thank you. Attorney Dominic Thomas, going to Thomas, 315 Main Street, Derby, Connecticut, representing the applicant. This application, 2416, was filed in conjunction with application 2417. In the prior 8-30G applications that I have filed before this commission, there was no need, because of the location of the proposed 8-30G project. Because of the locations, there was no need to do an amendment to the zoning regulations, because your zoning regulations, your plan development regulations complied with basically the requirement that the 8-30G be focused on a specific piece of property. Your plan development district, as has been held by the Supreme Court in the Tillman case, Tillman versus Shelton Planning and Zoning Commission, and also prior to that, Campion versus the City of New Haven Planning Commission, that a plan development district is an appropriate zoning technique and does change the zone on a specific piece of property. It is not a floating zone, it is actually a zone. So there was no need for me to do that, because I didn't need to address a zoning vehicle under your legislative capacity in which to file the 8-30G. However, in the initial considerations for this matter, the property at 85 River Road, the issue that was brought up when the previous voluntary set aside was proposed was that, because despite the fact that there was some argument made as to whether or not it was in a transitional area, this commission made a finding that it was not in a transitional area, and that it was in fact surrounded by residential zones. And therefore, when it's surrounded by residential zone, and by the way, this commission then supported that position in the 390 Shelton Road application. So that being the case, the need then in filing an 8-30G application for the site at 85 River Road, the need was then to also combine it with, or file it in connection with, a zone a zone text change to permit the 8-30G to be filed. Coincidentally, while I was in the process of filing these applications, 131 Beach Road LLC came down from the Supreme Court, and you can see how current it is, because it doesn't even have a Westlaw citation yet. They haven't issued numbers on it yet. And this was a case which dealt with, interestingly enough, quite a similar issue. And there were two things in this case that were significant. One is that the decision you make as a legislative wearing your legislative hat on a zone text change. If it's in conjunction with a 8-30G, it's governed by the same rules. In other words, the burden is reversed the same way as it is with the application, the site plan application, which is connected to. And I understand very clearly that's probably something you're going to want to seek council's advice on it. But my position on this is that I'll be glad to discuss this with you further here, because you go to the public hearing, but it shouldn't. This public hearing should be continued and be heard at the same time that you're hearing the PDD, the actual PDD application for the initial concept development plans. I believe, I think final site development plans. That's part of the 2417.
Well, could you expand upon that? Why,
Okay, well,
if we have two separate applications, one's for
Right.
text amendment,
well,
one's for an actual project.
right. In the 8-30G applications that you have received from me, because
For
Shelton.
this project or just in general?
In general, Mohawk, Fountain Square, okay? There was no need for me to do a change to your zoning regulations, because Shelton and other towns have adopted it, but Shelton has a vehicle under which someone can apply for an 8-30G and have that 8-30G application focused on a specific piece of property, which is, when you read this case, you'll see that the one part of this case, the 131 Beach Street, where that was reversed by the Supreme Court, was the fact that the applicant in that case filed the zone map change and map and text change in conjunction with their site plan application, but the proposed floating zone encompassed an entire zone. And the Supreme Court ruled, and I'm summarizing here quite a bit, the Supreme Court ruled that no, you can't, when you're coming in an 8-30G, you cannot utilize the requirements of 8-30G to come in and place the requirement on an entire zone. So if I came in with for example, if I came in with a zoning regulation that allowed a certain density under 8-30G in the entire R3 zone, that wouldn't be an appropriate way to approach it. You've got to do it parcel, by a specific parcel. So there's a lot of discussion, but I would call your attention, although there's a lot of language in here. If you look at page 11 of this, the pages are on the bottom. This is page 11 of the printout. Is where the language is most significant in the what would be the left-hand column as you're looking at about 2/3 of the way down. Are you screen sharing? Oh, I was gonna, okay.
I could stop.
Okay, yeah, you can go down to page 11 and I will read it. It begins with the phrase, the paragraph that begins, "We previously have considered the meaning of the phrase in connection with." And that phrase there, and it goes on to say, "We rejected the claim that 8-30G applies only to a zoning commission's administrative as opposed to legislative decisions, reasoning that the plain and ambiguous language of the statute applies to any application made to a commission in connection with an affordable housing development." So 2460 was made in connection with 2417 because 2416 is the vehicle to allow 2417 to be filed, based on the fact that, and I am taking the interpretation that this commission has given to that provision in 34.1 concerning surrounding a parcel that is surrounded by residential zones. So what the amendment does is the amendment simply says, yes, that is an applicable restriction, except when someone's filing an 8-30G application. Then an 8-30G application that can be filed in a parcel of property that is surrounded by R1 zones. And it complies with 131 Beach Street because your plan development district regulation is applied to only a specific piece of property. So therefore, the limitation that the court has in here, which is that if you're going to do that, the zone text change that you're making, or the zone map change that you're making, only applies to a specific piece of property. As you are aware, well, dealt with PDDs, a plan development district is a zone change on a specific piece of property.
This isn't a PDD.
Huh?
This is not a PDD. That application does not involve PDD.
The application that I made for the 8-30G is under the PDD reg with the regulation change that I proposed.
But why? I don't know
Because
why there
there's
would have
no
to be
other-
a zone
the other-
change to
So
do an
automatically makes it a
830G.
PDD, is that what you're saying?
No,
This text change automatically makes that property a PDD?
no, the text change does not do that. All the text change does, the text change is not related to any specific piece of property. The text change says that under 34-1, within a property surrounded by the R1 zone, someone can make an application for a plan development district utilizing the PDD process. It becomes eligible when it's an 8-30G. So instead of drafting a
Eligible
complete,
anyway. I
Huh?
mean, you can always try to make an
An
application
830G.
for an 830G on any piece of
He's trying
property.
to
No,
make it, he's trying
no.
to make it a PDD.
no,
Why?
no,
Why,
you
why,
can't.
why?
So
No,
they can get what
that's
they
not a correct statement.
I'm sorry, I'm lost.
Okay, that's not a correct statement. I can apply for a PDD and have applied where it is eligible for the PDD. So using the example that I gave you, 2 Mohawk is eligible because 2 Mohawk borders on River Road and has greater than 20,000 square feet. Those are the conditions. So in this situation, what I changed is I said, you can have a PDD in a residential zone, which you cannot do. I cannot go in and, well, the best example I can give you is something that was before you. Okay, if I were involved in the 390 Shelton Avenue, right now, without changing 34-1, it is more than sufficient size for a plan development district. It's more than 60,000 square feet, but it is, as determined by this commission, I believe, totally surrounded by residential zones. So if somebody went in there right now and made a application for 8-30G, they would not, the answer would very simply, you're not qualified. You don't meet the standards. So rather than draft an entire
Don't?
new you would not, because you're surrounded by, you've made that determination. I assume the applicant would be wonderful to hear you say, no, you can do it. You know what I mean? You can file for a PDD. So in order to have a vehicle to make the application, in most situations,
I am so confused.
that's why it is something that you probably would see. In most situations, if you read most 8-30G cases, in many towns, because the majority of the communities, the jurisdictions in the state of Connecticut do not have a plan development district application, plan development district regulation like yours. They have PDDs. Some of them have chosen to take baby steps towards PDDs, but they do not have one similar to your zone. So in those situations, have been a few cases where, for instance, people have gone in and proposed a new zone and a new text in which it's called the affordable housing incentive, whatever, and they've got to then craft it so that it can be limited to a specific piece of property. In 131 Beach Street, whatever they crafted to allow it, they called it a floating zone, or that was whatever they crafted would have applied to the entire, I'm not sure what it was called, residential A1 zone, you know, the whole zone along Beach Road and in the right off the downtown historic. This was next to the historic district in Fairfield. And what the Supreme Court ruled in here, and again, you can rely on your own counsel, and you should. What the Supreme Court ruled in here is that the standards of 8-30G apply to not just the site plan, standards meaning the burden shifts and the standards are stated very clearly about connection to public health, safety, welfare, but those standards apply to the zone change. But a zone change in connection to an 8-30G application must be limited to a specific piece of property on which the 8-30G is proposed. So in this case, contrary to the other 8-30Gs that I filed, which were both in zones that would permit a PDD, okay, or parcels that would permit a PDD, I needed to create a vehicle. And given the fact that your plan development district regulation as a zoning tool is flexible and it's served that purpose, what I needed to do, it does apply only to a single piece of property. Or if you combine, sometimes I think you've done it a couple of times where there have been 2 or 3 parcels, contiguous parcels. So it can only be applied. So in this case, in order to apply it to the 885 River Road, which is surrounded by R1 zones, and this commission has already made a determination that
Doesn't qualify.
it doesn't qualify for a PDD, so I had to create a vehicle. So the most limited vehicle I could create is to take 34-1, the section, whatever the subsection is, underneath it.
34-1.
And so,
It's 34-1.
34-1, but the last sentence relating to the restriction in residential zones and simply say, okay, if it is surrounded by residential zone, the only thing you can do there is if you're filing an 8-30G, an application that provides for 8-30G proposal.
And the text changes should not benefit just one parcel. Text changes should benefit the city in more ways than one, not just one individual. You start rewriting our regs to satisfy the needs of one parcel. It just doesn't. Why couldn't they just come in with an 830?
Yeah, I just don't understand
you
this
cannot-
argument.
There's
about
no,
the
you have to have a
PDD.
vehicle to file. What vehicle, I'm to the
We denied the
question,
PDD.
what vehicle would I file in order to under what basis, under what regulation would I file an 8-30G site plan on this property for the density I'm asking for?
I don't know, I'm not an attorney.
Well,
Well, I don't-
I am, and I read your entire regulation and I know them inside out, and there is no vehicle.
So what does that say?
That means I have to create a vehicle. That means I have to create a vehicle. I understand what you're saying, but I think you need to, you file an 8-30G in conjunction with a text change
Okay.
or a map change that permits it. I did not have to file a map change under your regulation because the PDD regulation is a map change on a specific piece of property. So I didn't have to.
Attorney,
Okay, Commissioner Kelly, you have a question?
yes, I do. Attorney Thomas, you mentioned density. What density are you looking for?
That's in the site plan. That's not before you tonight because you didn't do it. I think there's a proposal of 40 units in it. I don't have.
That's the original one?
No,
This is
the
additional.
plan development district that I mean, again, this is why both hearings need to be together. But the 2417, it places a PDD over the rear portion of the parcel. And frankly, I don't have the issues before me. The way I created the density and the 40 units on the top are governed by 8-30G as to their as to the requirement of 30% affordable, of which half would be at 80% AMI and half at 60% AMI.
Okay, but
What's in
when
the site-
we first saw the project and we talked about the project and we didn't approve the project, you talked about number one, the blasting, number two, the safety, the elevation, so on and so forth. These are all, certain criterias that we took in consideration with rejecting a project. Now, really, what you're saying is that, okay, you rejected a project. Now I'm going to try to do this and do it in A30G, so I get the project. Is that
Well,
correct?
There's no guarantee I would get the project. You have the same standards. The difference is the burden shifts.
Burden
But
shifts.
you-
When you say the burden shifts, explain this.
I have,
Yeah, the burden shifts to us. As a
the burden
text,
shifts to you, as
a
it says in
typical
here.
A30G.
Yeah, I think if you look at,
Our
yeah.
zoning laws go out the window. with it.
yeah, not
That's why I don't
necessarily. They,
Understand why the density, can I just, I really don't understand what you're saying. But I thought the 830G kind of overrode our density rules.
if you look at head note 2 on the first page, head note 2 is a very brief summary. Head notes are summary things.
On this
And
thing
it
here?
indicates that the court in an 8-30G must balance, determine independently whether the commission's decision was necessary to protect substantial interests in health, safety, or other matters that the commission legally may consider, whether the risk of such harm to such public interest clearly outweighs the need for affordable housing, and whether the public interest can be protected by reasonable changes to the affordable housing. That's a summary of what happens when the burden.
I understand all that.
So when in this case, and again, we're getting into the application that isn't before you because this application was the only one caught. When the site plan application is considered, all of the factors that Commissioner Kelly brought up from the prior one will have to be addressed by the applicant, have to be addressed in full evidence by the commission. And if the commission is able to substantiate that there is a substantial risk to health, safety, and welfare that outweighs the need for affordable housing, then
I
I
understand all
lose.
that.
Yeah, right.
You're not
I
getting
lose.
to my
But
question,
the-
I'm
the-
sorry.
Yeah. This doesn't, the text change doesn't do anything to any application, doesn't guarantee anything. It allows someone to file it. And your considerations are the same as they would be with any PDD.
Well, back to my question, if I can even remember, let's say, what about this particular property would preclude anyone coming in with an 830G application on it? Why do we have to
Because
change the regulations
you don't
to
have a-
accommodate? And why would
There's
we?
no regulation that you have that allows anyone to file for a density greater than the density that was approved
I thought
for,
in the 830G, those regulations about density no longer pertain.
in order
That's what
to
I'm
file,
asking.
no, it's, that is not, in 8-30G, if there is a regulation that allows X density that complies with what the 8-30G application, that the 8-30G would be under density. So for example, in this R3 zone, if you had a regulation that said you could have 76 units on a parcel of land that's the size of this parcel of land, then you're absolutely correct. You don't have that regulation. So the only way I could exceed the 36, which is what was allowed under your regulation, the 36 units that are approved. The only way I could exceed that is to craft a text change that would allow to do that. And so if you
Well,
look.
again, I'm back to the 830G, and I have spent, I think, our understanding that the density rules do not apply when somebody comes through with an 830G application. Am I right?
Not that they don't
No.
apply. You have
They-
to have a vehicle within the zoning regulation that permits the density that you're applying for. You can't just go in and say, you don't, I know you don't have any zone, I know you don't have any zone that allows this, but I want to apply for it and put it on this land. When you research the 8-30G, they're always done in conjunction with a zone map or text change.
Was it not staying down? It made it worse.
Which is this one?
Yeah, the first one.
No,
No, no,
No,
The
the one
first
you
one you
just,
were playing with.
There you go.
Tie it to the
Yeah.
chair.
There you go. Thank you.
Otherwise you have to stand there all night.
oh, yeah, you
Let's just stand here.
staple it to the wall.
Okay.
But anyway, so you can't just walk in on an 8-30G. You can't just walk into a zoning regulation, zoning commission and file an application for, to have let's say a 20 unit per acre 8-30G application unless there's a provision in the regulation that allows that density in that area, in that zone. So
Not
what
my
happens with most
understanding
of
that
them,
at all.
huh?
That's not my understanding
Well,
of that.
then, believe me, if you go, when you read this case, and that's why I said FC council, when you read this case, you will see, in fact, in order to get the, whatever it is, 30 units, 40 units, I don't know, the number, in order to get it in that location, they had to do a zone text change and a zone map change in order to get it in. The problem they had was the way they drafted it. It encompassed an entire zone beyond the piece of property that was a question.
So there.
PDD, you don't have to worry about that.
There exists right now, parcel of land in Shelton that has 36 townhouses on it.
Right?
There is more property attached to that parcel,
Part of that parcel.
and an application was made for more units, and that was
Under a
denied.
PDD,
Under PD.
under a voluntary affordable,
Yeah,
right?
and that was denied.
Right.
So there isn't any other mechanism, a DRD or a subdivision or
Nothing.
something else that would permit the applicant to come in and file for additional units.
On under 8-30.
No, just,
For any affordable, any additional, right? The only
Well,
vehicle
not
would be the
affordable.
PDD. Yeah, the only vehicle would be the plan development district. The only one would be, and the determination that this commission made was that that parcel was not eligible for a PDD. Similar to 390, similar to other, because they're surrounded by residential. So therefore, the only vehicle that then can be created is to come in with either some whole new elaborate text change and map change possibly, or, and what I honestly tried to do in anticipation of potential litigation, was create the narrowest situation by simply changing the language in 34.1 to allow an 8-30G if surrounded by the residential zones. Now, I didn't change anything else. So for example, right now, anything under 60,000 square feet wouldn't qualify, except, and I don't know if there are, but there may be, residential zones that abut River Road, Bridgeport Avenue, which are, I'm sorry, downtown, which I don't think there are any residential, which is 10,000 square feet, and River Road, which is 20,000 square feet, and Bridgeport Avenue is 20,000. So other than that, if somebody's going to do it like I'm doing it, you're bound by the size requirement and the other requirements, sewer, water, all the requirements that are in the PDD regulation. If
the original application for the units that are there now, was that remind me, was that?
That was a special exception.
Yeah,
That was a special exception,
right, and that
which
was,
is still permitted.
right, and then, so there is no way that the applicant would come in.
Max
You
the,
maxed it out.
and I cannot separate the parcel.
We got
Because
more
that
than
would-
we wanted,
Mhm.
Yeah.
more than we wanted to give.
Yeah.
to begin
I
with.
mean, the max under the computation was 36, which is what he eventually received. But that was based on the total acreage of the property. So therefore, I cannot even split off the parcel because that would make the existing parcel non-conforming.
So we had the first part was a special exception that was approved. Buildings went up. Applicant came back for more units under PDD, but we said it didn't qualify for PDD. So now this is your third attempt to get more units up there.
So what I'm suggesting is that you certainly, upon giving you this, is that you, it's up to you to seek your council's report, but also that this be kept open and be held in conjunction with 24/17.
What would that do if it was held in conjunction with that particular application?
Well, because it is in fact, as on page 11,
Mhm.
it is in fact a legislative proposal, meaning a zone change, in conjunction with, and it was filed in conjunction with, at the same time, both were filed
Mhm.
together, in conjunction with an application. There's a text change
Mhm.
filed in conjunction with your PDD application, which is both a zone map change, because when you do the PDD, you're changing the zoning map, and a site plan,
Mhm.
which requires you to file a concept plan followed by a final site development.
And
So you, compared to what goes on in other communities, your system of PDD is a little bit more streamlined
Uh-huh.
in that.
But way the proposed regulation is written, you feel that this would only apply to this particular parcel of land?
In conjunction with what I'm proposing,
Mhm.
it's because the one it's conjunction with applies to a portion of 85
It's
River
gonna
Road.
apply to anybody that wants to do this, not just this person.
No, it applies to, no.
We could try it.
No.
yeah.
It's,
Yeah,
in this
you have to
particular
come
case,
in.
it's only gonna
Yeah,
go. but
someone,
yeah,
someone,
Somebody else is gonna come in and use the same
someone,
thing.
someone can come in and I will tell you, and you can absorb. In fact, there are, and it's something that Shelton needs to consider, because it may happen. There are now 8-30G applications
Mhm.
going forward on septic because of the newly revised septic rules that have taken place.
Mhm.
So again, the parcels of land have to be larger, but there are some, and there are things in your R1, your your R1, R2, R3, R4 zones that may comply. The thing is, they would have to, for someone to do it, they still gotta be 60,000 square feet, and they still gotta comply with all the other
Mhm.
requirements. The problem with the ones that are coming in under septic is I believe your PDD regulations require that a planned development district has sewer and water. I did not propose changing that,
Mhm.
in your thing. I just put it in because the parcel that I'm involved in has and meets all the other standards.
So what is the benefit to the city for us to take action on this in the affirmative?
Well, considering it in conjunction with the others, I do believe, again, I'm advocating for my client that the increase in middle housing, the increase in further housing, the housing demand for that site has been very strong below. They want to be able to put more housing on the top. It's in a very good location. So therefore, bringing more people into the town is a benefit to the community from a housing perspective. But that argument, which needs to be supported by evidence
Mhm.
for me, and if there's opposing, the two applications need to be heard together. So all I'm saying is take this and continue it, take 24/17, and this is 17. This is 16, 24/16, and continue it to the same night of 24/17. And then you can also have plenty of time to consult with your counsel on the issues of the interrelation of the two applications and the limitations of the text change. Because in fact, in a normal situation, in another community, somebody could be coming in with a map change, a text change, and a site plan. 3 things in order to accomplish the filing of it, if it's not allowed under existing zoning. Your PDD is a zone change. I just needed the text to send the text change, and the PDD is already, as required by 131, limited to a single piece of property. Can somebody else on another piece of property, after the text change is done, can they file? Yes, but they have to, again, comply with all of the other requirements of the PDD.
I just find it a
still-
little ironic that
Go ahead.
we're constantly making decisions under the veiled and sometimes not so veiled threat of 830G, which we know is a terrible regulation imposed on us by the state. That being said, why would we make our regulations even easier for you to do that? I just,
Well, in making that decision, as
if we wanted the density there, we would have approved the PDD. We would have.
That, can I just,
Although we couldn't because it did
I'm
not.
still not getting this, sorry, but Mohawk, for example, that was a piece of land that supported under the existing zoning, maybe two houses.
It qualified for a PDD though, because.
But did we change it to a PDD? I don't
no,
think we did.
you denied
We
it.
denied
The
it.
matter is set for mediation in October.
Right, I know we did. I know we denied it, but,
But that was what
We-
the application was for.
Right.
For a PDD.
and they might,
Qualified for PD, so they were able to file it.
Qualify for a PDD, a small portion of the piece of property touched on River Road, and under your regulations under 34. One, because it touched on River Road, it was eligible as
right,
long as
so
it had
the
20,000.
application was both for a PDD and for an 830G at the same time?
The application
I thought it
was,
was just an
the
830.
application,
We
Denied it, and
Okay.
then we came in with it.
And then they
Yeah.
came in with
the
Okay,
application
all
was,
right.
the application was.
qualified.
Good quality,
Yeah.
but so what?
This one didn't qualify.
This one doesn't qualify.
Yeah.
So he's trying to make it so that it does.
And
By
what-
changing our tech zoning regs.
And why would that make us want to have more density there? No,
It would force
It
us to
just-
have, more density there. It's
Why?
not that
If it's
we
a
would
P-
want it, it would force
force
us.
us.
because I'm sorry, I'm just, my head is spinning, but I just don't
Well,
know why
we
they
tried to
can't
read
just
this.
come
I
in with an
mean,
830G on that property,
Because your regulations
because that would,
don't, your
override
regulations,
our
there's nothing under
density.
your regular, I have to have. And believe me, I have clients that come into me and say, why can't we just file it? And I bring out the book and say to them, because I can't find anything in this book that allows me to file it. I have to look at your Schedule A, and I have to go down your Schedule A and find something that fits the application and fits the zone and fits it. I have to do that. So if I don't, in the case of Mohawk, it fit, and I filed a PDD with a 8-30G site plan.
Attorney Thomas, with all due respect, don't you think that all the previous iterations of this commission would have, if they felt that it was necessary for this to be done, they would have done it a long time ago? We have a plan of conservation and development. We have people who've been on this commission for years prior to my going on. If they felt that it was appropriate, why didn't they do it on their own without being prompted?
The simplest answer to that is this. We have, and there's an article a day, an enormous housing shortage. And the primary blame on the housing shortage has been placed on our zoning system.
Can you document with it?
Oh, I mean, it's in, I mean, I can
Reading
give
that.
We are
you,
doing
I-
more than our fair
Yeah.
share to put in
Right.
affordable units.
and the whole point of 8-30G is when there are situations, again, it is a balancing act. The balancing act tips a little bit more towards the applicant if they're going to do 30% affordable in accordance with the statute. But, you know, this case is a very good read to explain what the balancing act is. And just because a commission has decided not to increase density, and if it has decided not to increase density, That is why developers use the vehicle of 8-32. And so, again, all I'm saying is, I had to create a vehicle. In your situation, compared to all the research I did, the easiest way to create the vehicle, to allow it to be done, focus on a single piece of property. And in this case, I did not bite off more than I could chew. In other words, I didn't go into the 34 and start knocking off other requirements. I can't tell you that somebody else in the future might not do, may or may not do that.
Gonna open up
But-
Pandora's box.
Yeah, well, it's, the Pandora's box is the fact of, there are a lot of areas. There are a lot of areas in the town that don't have the infrastructure to support it. But I'm just telling you up front, and I'm not trying to hide anything, that in the future, as it's coming down, there are projects, one which I was just approached on, to do a voluntary affordable in the town that is 35, 40 units on a sizable piece of property, but all of them on septic. And because it's the larger pieces of property, and there are towns that are leaning that way, you know what I mean, and looking for the voluntary affordable to increase their affordable housing stock, because at 80%, it's obviously more workforce housing.
Okay, if there's any comments, questions, or concerns from the commission, either those that are here in the auditorium and those that are participating remotely, before we go into the public portion. Okay, hearing none, so I'm going to turn down unless you have something else to say.
Nothing further, just my question.
All right, so if there aren't any questions for the applicant, I'll move to the public portion. And I'll start out with elected officials of the city of Shelton that are in the auditorium that wish to speak. Okay, and there are none here in the auditorium, so I'll ask if there are any elected officials of the city of Shelton that are participating remotely, either through Zoom or through a phone link. Please use Zoom's raise your hand feature or dial *9 on your phone to be identified. No, there is no public official participating remotely. So I'll move to any members of the public that are here in the auditorium. And we do have a Rebecca Douglas who is signed up. Come on up to the chair up here. Identify yourself for the record and go ahead and make your comments. Okay. Addressing the merits of the application.
I'm Rebecca Douglas. I live at 56 Woonsocket Avenue in Shelton.
Mhm.
And I have to agree with you. I have no idea what you just said. I can understand why there isn't a bigger audience here, because when lawyers talk like this, the average person hasn't got a clue what they're saying. I don't know if I can say this at this time, but the next article that you're going to bring up has the same amendment attached to it, where
Concentrate on this.
yes, the same text. So is that the same thing that he's talking about now?
No, it's different.
Oh, okay. I just want, that's what I wanted to be
Category
sure
would
of.
be the fall text amendment, but it's a different.
Oh, okay, but I honestly don't have a clue what this man just said. And it's going to affect some part of this town that I live in. I guess that's why I'm here. I want to know what's going on in my town, but this is like mind-boggling. So that's all I wanted to say.
Okay.
Okay, thank
Thank you
you.
very much. I understand your angst.
I don't get it.
Okay, is there anybody else from the public here in the auditorium that would like to address the commission on this issue? If not, if you are participating remotely, please use Zoom's raise your hand feature or dial *9. And Ms. Castro said that we do have somebody participating remotely.
We have Mr. Tom Harbinson.
Okay, so Mr. Harbinson, please identify yourself for the record and proceed.
Thank you. I'm using a new computer. Just want to make sure. Can you hear me?
Yes.
Yes.
Terrific. Tom Harbinson, 15 Soundcrest Drive, Shelton, Connecticut. I had a couple questions that I was going to ask, but Attorney Thomas's comments led me to some other things. Regarding the 131 Beach Road judgment, on page 11, it says we previously considered the meaning of phrase "in connection with," and that's in quotes in the ruling. Attorney Thomas used the word "in conjunction" several times, and I don't know if there's a difference between conjunction with or connection with, but clearly the legal ruling here says connection with. The second thing was on the summary item of that Beach Road ruling, particularly summary item number 2. It talks about halfway through item 2, the commission's decision was necessary to protect substantial interest in health, safety, or other matters that the commission legally may consider. So I'm curious as to what that means. I've always known that the ability of a planning and zoning commission to deny a affordable housing application had to do for issues of public health and safety. But I'm not sure what this other matters that the commission legally may consider would entail. Next, in answer to one of the questions I'm trying to confirm, there was a reference to the Mohawk Drive application for affordable housing. And I believe that fit within the PDD because in section 34.1, one of the areas that a special development area can occur is in the delineated coastal area in the vicinity of Pine Rock Park and other portions of River Road characterized by established non-residential areas. So I think that's why that qualified in that location, and if you can confirm that. But we have seen other 830Gs applications occur in town on properties that are completely surrounded by residential property. Notably, the Huntington Congregational Church that was initially proposed as an 830G, and then its time ran out, but it then proceeded under that 830G approval. So that has occurred in town. To have an 830G PDD application occur in an area completely surrounded by residentially zoned areas. Although in that location, I was told that the gas station on the other side of Huntington Center is what allowed that to qualify as a PDD, which I totally do not accept. That was told to me by Rick Schultz back when that was an application. And then Attorney Thomas referred to the commission determining about PDD applications in areas that are surrounded by residential areas. That has not been determined by the commission. That was a opinion given by Attorney Teodosio, specifically on the 390 Shelton Avenue property. And at the last special meeting that the planning and zoning had, Attorney Thomas may not be aware, but the commission had a consensus to deny that application, and specifically led by Ruth Parkin's comments saying that she didn't agree that a PDD was applicable in that location due to its nature of residential zones in the area. The one thing that I did want to talk about before I said all of that was that there has been this opinion that non-residential areas can include dedicated open space. And so I know it's outside of what Attorney Thomas perhaps wanted to see in this amendment to our zoning regs, but I would suggest removing entirely from 34.1 subsection B on property abutting and or adjacent to an established non-residential area for the purpose of accommodating a proposed use and development that will provide an effective transition in land use and buffer to the adjacent residential neighborhood. The concept that a dedicated open space or a farmland that has had its development rights purchased and will never be a residential area can somehow open up an adjacent property to be eligible for a PDD is abhorrent to your plan of conservation and development. An alternative to that is to, on item B of 34.1, where it says non-residential area, to say non-residential zone. Also, that appears in item A. So to refer to actual zones, because that's a defined element of your zoning regulations rather than an ambiguous area term. That is all that I have to say. Thank you very much.
Mr. Robinson?
I assume he's suggesting a different text change, not
Yeah.
text changes to the current proposed text change.
Mhm. Separate. Okay, anybody?
I'm sorry. Are you saying that we cannot amend what is proposed here?
No, this is,
No.
it's the applicant
This
that
is
would
the
need
applicant
to,
that's
proposing.
proposing.
And so he's proposing that. So if the commission felt that this presented an opportunity to modify the PDD regulations further, they could do so.
We'd have to have a different public hearing, wouldn't we?
I don't see how if you decide to amend it, but I don't know, that maybe for an attorney to decide. Thank you very much.
That will be addressed after all the public comments are received. Anybody else, Ms. Castro?
No, that's all.
Okay, last call. If there's anybody participating remotely, please use Zoom's raise your hand feature or dial *9 on your phone if you'd like to address the commission on this particular matter. Okay. All right, so Attorney Thomas?
Well, just briefly, to address the last thing, the commission has the right, when somebody makes an application, to approve, deny, or modify, but it would be related to the language that I suggested in the approval, as opposed to that. Certainly, commissions can have discussions with applicants about making other changes, but specifically what Mr. Harbison was referring to was a situation where when an application is made for its own, I mean, mine is a few words, but let's assume the application were a whole paragraph, the commission could approve it, deny it, or make changes to that paragraph that's being proposed, not other sections or other parts of the thing. So that's the answer to that. And maybe Mr. Harbison didn't hear me, but I did say that this commission made that determination in 390 to deny it. That was my point. Not that in any way that was approved, and I don't think there's a need at this point to rehash anything. It was not an 8-30. The 8-30G was filed after the initial one was denied. What was designed as a PDD, and the discussion that took place there was that the entire church parcel was church parcel residential. Remember, this was a church parcel, and did it abut that, plus the fact that the entire parcel then abutted public highway, public highway, on which on the other side was, of course, your commercial zone of center. But I don't think it had anything to do with it. That's why I'm not, in this case, it's totally different. Totally different.
Okay. All right, any final comments, questions, or concerns for Attorney Thomas? The applicant has requested that this public hearing stay open and be continued. So is there a motion one way or the other?
But why is it being continued? So that it can be attached to the other application?
Yeah, it is. And again, Mr. Harbison pointed out
Is that,
the word conjunction
I don't know
versus
what's that
connection.
legally.
I guess that's
I don't know.
77-year-old eyes, whatever. But yes, it is in conjunction and in connection with the application for the site plan.
But I'm
for the
just
being.
wondering if by doing that, it's going to open ourselves up to this legal challenge.
I don't know why they weren't here together. Right.
I don't know. I was just told
I don't know. there
this was the only thing on tonight.
Reference that this is connected to and.
Right.
in
Yeah, that's it.
conjunction
Yeah.
with.
Yeah. What he was
So if
saying.
we treat this as a separate and not in conjunction with this application. Are we setting ourselves up for a legal challenge because we?
Well, I would appeal that in that I filed them. I filed them in connection with each other. They were filed at the same time. You can't file them both in the same application. One's a text change, one's a map change. If you didn't have the PDD, I would have had maybe three applications, a text change application, a map change application, and a site plan. Your PDD application combines the map change and the site plan into one. Your PDD reg, I'm sorry, combines it into one.
Oh,
So I have filed the two applications. They are in conjunction with each other. So all I'm telling you is, I mean, I think it's one of those things based on your responses to me tonight, certainly need to see. Advice of your corporation.
Yeah, I'm waiting, Attorney Titoso is, on his way.
I was coming here.
Yeah, he was planning to attend a meeting, but he could not be here before 6 o'clock. So.
Because my question is, if we keep this open
Mhm.
for whatever reason, I mean, there's not a lot of people that seem to be want to speak to it. If we keep it open, can we, at the next meeting, say we don't want to include it with the other application and just close it then?
Right. Well, seeing that Attorney.
Well, if you don't include it with the other application,
The
the other application,
can't go forward.
I can't file, so I gotta appeal, you know, because there's no vehicle in which to go forward with the other application. You know, that's why they're connected. One is a vehicle to allow you to do that. And I'll be talking not 8-30G wise, but I'll be talking similar things when you get to the next application. But that's not related to 8-30G, it's just related to the connectivity of applications as they relate to the neighborhood, so to speak.
I was just gonna say, I'm trying to get it out. So she was gonna declare a recess to reconvene once Attorney Titoso is with us. It should be within 10 to 15 minutes.
Well, you know, I mean, if you want to go to the other one, in case, I don't know if he's gonna be commenting, no.
No, it's in a recess. Thank you. So recess is at 7:05. Yep. Okay. Ladies and gentlemen in the auditorium, we're going to reconvene as soon as we're back online.
Yeah, I had to reconnect.
Oh, I get it. Okay.
All right, ladies and gentlemen, here in the auditorium, and those participating remotely, we are reconvened as of 7 p.m. I'm just gonna wait for a minute for a microphone to be muted.
I'm on it.
You're good? Okay, so, we are, still in, the process of, hearing application 2416. The applicant didn't make his presentation. We did have, the public portion of the hearing. We recessed, in order to give Attorney Tito time to, arrive. Apparently there was some humongous traffic jam and tie up on 34 and on the bridge in front of St. Michael's Church. So he's close, but, not here physically. So I feel comfortable in moving ahead. So we're at a point of deciding among the commission whether or not to continue or close the public hearing. What's the feeling of the commission on this?
I don't see any benefit to keep it open. We're not
Strong
looking-
move.
We're not looking for any additional information. Let's just close it.
Do you want to make a motion to
I'll
that
make a motion
effect?
to close the public hearing.
Okay, there's a motion to close the public hearing from Commissioner Perkins. Is there a second?
I'll second.
A second from Commissioner Motto. So on the motion to close, do roll call vote. Commissioner Kelly,
Aye.
Commissioner Motto,
Aye.
Commissioner Cristiano,
Aye.
Commissioner Tiki,
Aye.
Commissioner Parkins.
Aye.
And chair votes aye. Motion is passed by a vote of 6-0. So this particular application will be discussed at a public hearing. I mean, at an upcoming meeting of the commission, but we do have the option to discuss it at this time. If anybody in the commission feels that they would like to do so,
No, I'd rather get
moving
the
on.
opinion of.
Corporation Council. All right, so the next public hearing is for application 2418, Dominic Thomas for David Schechter for a text amendment to Shelton Planning and Zoning Commission Regulations, Section 35, Table 1. Commissioner Amato, would you read public hearing notice?
Initiation of application 24-18, Dominic Thomas for David Chukka for a text amendment to zoning regulations, section 35.13, table 1, regarding setbacks from tract perimeter property line and minimum dwelling spacing between land owned in common.
Okay, thank you, Commissioner Amato. This application was accepted for review on July 10th, posted to the city's website prior to the opening of this evening's public hearing. It's the application for a text amendment, 2 letters, 1 email, and 1 petition, all opposed to this application. Ms. Castro, were there any other reports, materials, or correspondence received within the time period for this application, but not yet posted to the city's website that we need to acknowledge for the record?
No.
Okay, thank you. So Attorney Thomas, I see that you're here. Would you identify yourself for the record and proceed?
Attorney Dominic Thomas, Conan Thomas, 315 Main Street, Derby, Connecticut, representing the applicant. In a similar vein to the prior one, this text amendment was separated from a zone map change application to which it is related. And it was our intention, hopefully at or about the time of the public hearing or prior to the public hearing on the 2 of them, to also come in with a special exception application under the DRD. So with respect to this specific application, the change was very simple to the table A. After having gone through, as you remember, there was a prior application related to the development of these properties. And if I could screen share, I think, and this is one of the reasons why applications sometimes need to be looked at together, but if I could screen share.
You should be able to.
Okay. So this application, the other application that's related to it, I think these are not 18 and 19, I believe, I think 22, 24, 18 and 19. This application is the application of the area of the other, of the zone map change, map amendment application, which shows you that this is Constitution Boulevard. And these properties are zoned a hodgepodge of R3, R1, the R1 being a portion of property cut off from the other side of the road when they did Constitution Boulevard. R2 and R2. So they are developable as they are under subdivisions. So people can, the applicant, the property owners can develop this and come in with a subdivision that complies. There are limitations on this property relating to wetlands and the headwaters, but each of the parcels, excuse me, each of the parcels that are involved in the zone map change are zonable and developable in some fashion. From the very beginning, the discussion was this property would be best developed in some form of a cluster development, and therefore utilizing a vehicle that would allow a substantial portion of it to be given open space, especially that portion of it that is down here, which is referred to as the headwaters of Ivy Brook and abuts this parcel here, which is owned by the city of Shelton, open space. So the whole purpose of this, again, was to create, this situation, make it all R3, which is similar to the property up here. And then the vehicle that was best suggested was a DRD. Now, a plan was proposed and withdrawn, which would have had access through Woonsocket and that area there and along Waybosset. Okay, Waybosset, a portion of which is a paper road. So that was a proposal and that was withdrawn. The applicant went back to the drawing board and we looked at the DRD regulation. And we went through the DRD regulation and design residential district and checked off, can we do it if we did this? And there were some concerns, there was some ambiguity. But after looking at all, the one thing that created the biggest issue to the DRD was the 75-foot buffer requirement from the track. And when you take, especially on a size like this in the R3 zone, when you take and you put a 75-foot all around, you're eliminating the ability to do an effective DRD, especially here where you have to accommodate wetlands and other factors. So the proposal was that we change that one regulation, modify this, and then be able to come in with a proposal that comes off of Constitution Boulevard, that does not go through the neighborhood. So to better explain and understand it, although I haven't yet received the full set of plans to file under the DRD, which client is prepared to do, even though you're considering the zone text change, and the zone map change. And so this is what it would look like. This is the draft.
Has that been submitted?
Huh?
Has that been submitted?
No, that has to be the
That's for
special
the other
exception.
application.
Well, it will be in conjunction with the other application once we find it, but I just wanted to do it for illustrative purposes to connect all the dots. Why are we doing a text change?
Mhm.
We're doing a text change so we can use your DRD. It's connected to the map change, but you're facing.
Mhm.
And the end result would be something that looked like this.
Okay.
So that there could be access could be off of Constitution Boulevard and would then all the parcels between it and the other R3 development here would end off being, the development would be in this area and everything else would be open space.
Okay, why are you calling for exact elimination and not just a reduction of that setback and track perimeter?
Because
Property line.
within the framework of your DRD, you have the ability to impose buffers as the site is considered. So you have the ability to do it. It's a special exception in
Mhm.
there. So that it doesn't mean it goes to zero.
Mhm.
Because when you read the rest of your regulation, you have the ability to address buffers and you have the ability to impose them as you see needed. So for example, in this situation here, and I probably should have put up the aerial view, but in here, when you see these R2, you see the end of this road here,
Mhm.
Sunset. These houses that abut here, abut the property here, are up by the road.
Mhm.
There is a substantial natural buffer. They're one family lots. There's already a house built on it. The house is way away from it. If there were a situation where, as in this corner lot, where the house is, this corner lot up here on where there is a house there, the commission has the ability to say, well, you need to enhance the buffer in that location, because that's what's in your DRD already.
Mhm.
You know, you have the ability to do that. So rather than establish a blanket number and apply it to all the properties that you would want some form of cluster housing on, to enhance the amount of open space, which is what the DRD does, you would be doing it on a site-by-site basis.
Mhm.
And because under your special exception requirements, you can consider the impact, the intensity, and the impact on the neighbors as your normal, considerations. You then can impose a buffer where needed, an extra buffer
Mhm.
where needed. So I felt there was no need to put a blanket number in there where you may decide it isn't warranted, given the topography of the parcel and the topography or existing foliage on the existing properties. So that was the purpose of, this zone text change. It was step one to go to step two, which is to rather than have these parcels develop in accordance with multiple cuts. I mean, the plan to develop it as it exists would have two probably cuts, 2 or 3 cuts off of Constitution Boulevard, a couple which would be driveway and one which would be a road.
Mhm.
And that way you would accomplish, and you'd have a parcel of land, frankly, that is developed as a subdivision with a small portion of it being R3, R3, and this portion R2 subdivision. So you'd be able to do it, but you'd have multiple cuts. That was the whole reason why at that time, Alex and Tony Panico suggested, what can we do to do it? We even looked at, since we had this discussion, we even looked at, well, with the R3 parcels, if you did it to R3, could you get a density similar to the project we talked about just before, off on River Road. But you couldn't, because this is R2, and R2 in this big parcel here is R2 and this is R1. It wouldn't allow. There was no vehicle for cluster housing. So the best vehicle was the DRD. And the DRD, that was, we had to look at the DRD and we had to address issues with the DRD, and we've realized that we could develop it, the applicant could develop it and still maintain the separation of the buildings that is required in the table and in the regulation. But the one thing that would kill it would be the mandatory 75-foot track buffer
Off the top of your head, Attorney Thomas, was the R3 zone that Ridge Lane homes are situated on? Had there been a zone change for that? Because it's
I'm sorry, for,
adjacent to this property are a number of homes on Ridge Lane. And it's zone shown as R3. Do you have to know if years ago that had
Well,
been changed somewhere
I
along the
will
way?
tell you this, I was involved with the Sullivan family when they were doing, the Sullivan family owned all the property down the bottom where Neem Street was.
Uh-huh.
And when they were gonna do Constitution Boulevard, I was involved with them because they were clients of Joe Sylvester at the time.
Mhm.
And I was involved with them and when they were developing what was gonna be Constitution Boulevard. And of course, it all related to Mr. Vargas. That subdivision, to my understanding, was developed by Chris Vargas. What, I think it was Chris Vargas, I'm not sure, Chris or James. But I am not sure whether they changed the zone to give him R3, to
Mhm.
get the density or not, but we're talking about in the eighties.
Yeah,
You know, when.
exactly.
Yeah, we're talking about in the eighties. I'm not sure whether it was zoned, because in this area, if you look at your zoning map, it is a relatively hodgepodge of different, you know, R2, R3, R4. Then you go a little farther, you're an R5.
Can I just,
Yeah.
sorry, just to clarify, so the piece on the right.
This
is-
one,
Yeah, that triangular.
yeah, why is it?
In the blue. in the
Yeah,
blue.
it's not moving too well, but anyway, I
So
understand.
the plan that you haven't really submitted, but you're gonna have those lines go out to Constitution Boulevard, cut through. That part would be developed. in
Right,
this
these
DRD.
are, there are 4 parcels of land involved in the zone change, which this.
It's
Maybe,
like
if-
2.
hold on a second, maybe
Yeah.
a piece of paper will be helpful to my,
We're discussing another application.
yeah, right, yeah. But there are, you know, this is a, yeah, this is mine is just a,
Understand.
He's
text-
trying to, yeah, he's
I'm
trying
trying
to
to
paint the
explain to
picture
you.
why, but.
Yeah, explain to you why, but yeah, there are 4 parcels of land in this application. It's hard to see it. There's one
Yeah.
tiny triangle in the bottom. There's a larger piece, that's R1. And then the triangular piece you were talking to is R2. 3 parcels, I'm sorry.
So. Where's the text? Yeah.
Attorney, Commissioner Cristiano?
So, Attorney Thomas, the R4 area to the east, are those existing homes?
The majority of them are, yeah. There are a few, and there, as you get closer to Waybosset, there's some empty, but most of them are homes. They're
Yeah, small ones.
yeah, small lots, R4.
Corn Gardens area.
Yeah, right, exactly, Corn Gardens. I mean, the general opposition at that point was not wanting to have the development go through, which, again, it's technically a matter of right as with its existing zoning. If you're in a DRD, this commission, there's no guarantee this commission would do anything or act in any specific capacity, but it has a substantial amount of discretion under a special exception, under the DRD, to address the issues of access, open space, and everything. So,
I understand that
yeah,
the development could go through those existing streets and connected to here. There's also consideration to now eliminate the buffer that these folks purchased their property and expected to have when they purchased the property.
no, there is no buffer. There is no buffer requirement in the R3 or R4 zone or the R2 zone. So if the triangular piece that's in blue
Mhm.
that abuts Waybosset, or the piece right next to it that isn't in its zone change because it's already R3, if they were developed, there could be houses all along that street. There would no buffer under your current zone.
Still need the setbacks for a regular subdivision.
Yeah, you need a regular setback subdivision. That's, you know, whatever, in that zone, probably 20 feet, 25 feet.
So again, we do text change amendment. It's only for this particular.
No,
No,
this is the
That's what I
whole,
want to
this,
get out.
yeah, no, that's the whole reason. The whole reason why you have to file things together, you know what I mean? That's why I filed these two things together and we filed it with the intention and the clients are here, they're working on it. Mr. Grasso is working with the Chutkas and everything. And we have, as I showed you, the basics of the plan with the special exception under. In a normal situation, a client's not gonna spend the money to do the special exception plan, the full plan. That's costs money to do that. But the hope that it would explain it to the neighbors clearly and all that in the hope that it would, be presented as a package. We're working on getting that file so they can all be considered together and especially the people in the neighborhood to look and say, okay, I see what they're doing. But I mean,
Yeah.
also acknowledging that this commission.
so I know some of the commissioners were not on, the DRD is not old. I was
Oh,
on
no.
the commission when that was done, and it was done as a mechanism because the old planned
PRD.
residential PRD wasn't working, and we were looking for something to be a little bit more accommodating, if you will. But Tony Panico was with us, and there were parameters put in place. So you give a little, it's like the PDDs, you give a little leeway, but there's parameters that have to be followed. Just totally eliminating the setbacks. I just don't see.
No.
I just don't agree with that.
I mean, if it's not eliminated, then this property cannot, there's no way this property can be developed as a DRD. And you're eliminating in general, and I'm very generalizing, you're eliminating most of the parcels that you would find in the R3 zone.
Mhm.
Even though it applies to the R3 zone, you're eliminating most of those parcels from being, and push them into the other regulation, which if it complies, then you're talking about attached units. The desired
What?
attached units,
Okay.
just like on River Road.
Uh-huh.
In other words, there is a vehicle in the R3 zone to do attached units if you have a large enough parcel.
Mhm.
The clients here did not want to do attached. They wanted to do single family.
Mhm.
And there was no, not a desire or, excuse me, not a request on the part of Alex or Panico to take that regulation to that line item in Schedule A and change it from multifamily, which is, it requires you no less than 4 or more than 12 units together. In other words, that's the way it's defined. So you've got to do attached units. So if we were going to take it and add single family to that, there's no desire to do that. Let's use the DRD. We already have it. And we were discussing before Mr. Panico retired, we were discussing what tweaks had to be done with it. And one of the points I had made to him, and I'm not going to represent, he didn't make any comments on it at all, because when we were discussing this, it was just around the time that his wife passed away, was that the fact that you have the discretion, if you read the DRD carefully, you have discretion to impose your own buffers given the circumstances of the site. If this is not passed, then the client would probably, it's going to develop his property, and probably on the R1 piece, you could probably get 3 lots with probably maybe one common driveway and one singular driveway off of Constitution Boulevard. And then on the combined R2, R3, the 2 parcels together that are R2, R3, you'd probably have to put a road in. For instance, our proposal is private roads, but the one we're going to be doing would be a private road. But you would have to put a dead end traffic circle in and put whatever R2 is what, 20,000 square feet? R3 is I think 12,500 square feet. So you'd have to get lots that fit that configuration. But without removing without giving you the discretion under the DRD to impose your buffers based on site conditions of the property, at 75 feet, it becomes
I
undeveloped.
just know the time that was put into developing this regulation.
I like the concept of cluster zoning, but and I don't know that the DRD is as liberal as it might be, or is, that maybe there, it could be improved, but I don't know about changing a regulation for one property without looking at the implication of the
Well,
whole.
that's when the DRD was
Yeah.
designed. That's one of the things that Tony Pennico did, was to take a look at all the properties in the town that could
Right.
utilize it or
Yeah,
not.
and like I said, maybe it could be changed to make cluster type projects more doable.
That's what it
Seems-
was,
Right,
that's what
yeah.
it was designed for to begin with.
Right,
But with
but there
parameters
were-
put in place.
Right, so I don't know if those parameters are necessarily the best parameters, but it's a huge project to consider any kind of change like that, more than just looking at one project, I think. Yeah.
Can I ask what a DRD is? Not to- You can when it's public.
I can make.
Okay, well, yeah, I mean, I think rather than, AJ is part of the applicant
Yep. Mr.
process
Grasso.
and you can, point out a couple of points
Sure.
As
about
long as
the
it
proposal.
addresses
Huh?
not
This, the text.
Well,
not the-
in addressing the
would address.
text change, yeah, okay.
So
Okay, Mr. Grasso, identify yourself for the record.
AJ Grasso from Prestige Builders. I live at 14 Red Tail Court, Shelton. So when we were discussing the number of units in regards to density, currently under the regulation, we would be allowed to have a total of 26 units if they were attached under the regulations as they are. If there was an
The
R3,
DRD.
no,
who was-
So
through
zones that
an
are-
R3 zone. Now we butt up against R1, R2, R3, and R4 properties. The reason we were led towards the DRD from Tony Panico and Alex Rossetti was the fact that would allow us not to impact the entire parcel. It would allow us to leave the old church parcel below the head wall completely undeveloped. The piece to the right, if you put the triangle back up there, piece to the right on Constitution Boulevard, if we took a triangle all the way down, we would then not develop that either. So we would be giving about 35% of the property as open space. But under your current regulations in an R3 zone, if we were to get an R3 zone change, we're allowed, what they do is you take the total acreage, you subtract wetlands and steep slopes. And then you divide it by 10 or 12,000 and you end up with 26 and a half units that can fit currently into your zone. We'd rather not do attached units. And the other reason why we want to do this, it allows us to not come off any of the side roads. No one's gonna have to drive up Sunset. No one's gonna have to go to the end of Dogwood. No one's gonna come in from Waywasset. It puts a permanent dead end on that whole parcel. And in regards to the buffer, whether you put a 10-foot, a 20-foot, a 30-foot, a 75-foot buffer, if we put a hard number in there, one, it's not going to be able to be used anywhere in the entire town, probably in an R3 zone. And it's already written for an R3 zone. I believe I'm also the only other person that's had a DRD approved on Nichols Avenue, and it worked out very well. And another reason why the DRD was, I'm assuming why it was implemented, was because then the road becomes private. The town has no expense involved. And you can now they take a minimum of 30% of the land as open space. In our case, I believe we're giving closer to 38% of the land would be given in open space. And that whole area would be undeveloped. There would be no impact to that, there'd be no trees cut, there'd be nothing done in that area. That's the reason why we're in here for the DRD modification. And that we were led that direction from Tony and Alex.
I mean, it says 75-foot buffer track. I think that's, I don't have, I can bring up my application, but I mean, it says track, You know what I mean?
Not even sure what track means.
Yeah, we don't even know,
because
we don't even know what tract means, number one. And does it mean to the house? If you're doing common ownership? Or does it mean to what?
that
So
track
for
is-
example, you know, there is an issue with it, the way it's written. Because, I mean, in fact, in this case, even if you went to the house, you'd be, because you're talking about the track, and what you're doing is does the track include the open space? The open space is given to the town, so what's left after you do it, so, I mean, again, this is a situation where I strongly suggest, rather than just say, oh, I don't want to change a regulation, I think the regulation should be heard together with the other portions, but you seek advice from whether it's your council or even others as to what the real meaning of that, how does it impact?
One of the things, Dominic, if you could put the map back up for 1 second.
Did you go back to the minutes of when this DRD was developed?
I didn't do that. I was actually working with Tony Panico and Jim Swift. We were developing, it was being written to be used on the property off of Booth Hill Road.
Which was denied.
Yeah, which was denied at that time.
That every place deserved it.
Huh?
If anybody, if any property qualified, I thought it was that one.
Oh, I agree with you,
I
but
wasn't on
I,
the commission then, so.
yeah.
And if we can go back to the map for 1 second, because what we need to take into consideration here,
I think it's from where the open space that's being dedicated.
so.
Because that's, I mean,
The map, there
if
you
you
go.
look at the 75, I mean, the others are 20, 15, 30, 30. This is 75. There was definitely a reason.
What do you mean the others were what?
The other setbacks. The
Well,
side
those are setbacks. Those are setbacks. Keep in mind, those
So is
are,
the
It
75.
says setback from track.
huh?
It says setback from track.
Track, okay.
Perimeter.
So what
Track
they're saying,
perimeter
yeah,
property
so,
line.
okay, so what, again, and that's, and, I mean, let me just,
One of the things I wanted to point out,
Yeah.
Dominic, on that map.
Okay.
So if you look on that map where Dominic's cursor is, if you look straight above that, where the open space is, there's, no matter what buffer you determine to put with that open space, there's nothing going to be developed in there. To the right of that, or to the east, where there's a road and a paper road, there's no abutting home. So we're really only talking about the lower parcel,
Mhm.
the bottom portion of that.
yeah,
And that's the part, that's the reason why, I think a commission imposed, buffer suggestion or requirement.
so.
That's how we could address that.
So setback from track or perimeter property line, 75 feet, 75 feet on both ends. You know what I mean? In other words, doesn't even distinguish between the two. And certainly, does the track include the open space? So if the track includes the open space, okay, and again, it's still gonna be a problem with this site because of the property that's along the, where you have those lots where the houses are way on the other side. But if you're measuring it from the track, you have to, at some point, you have to convey the open space to the town. Or the open space could be conservation easement, but in this case, in this one, this is open space that's gonna be conveyed to the town because it abuts town-owned open space already. So where do you measure it from? But the whole point being, here is, you have 75 feet covering all R1A and R1 parcels. Those are most likely going to be very large parcels in the R1 and R1A zone. They're 10 acre, there's a 10 acre requirement. You can have smaller ones if it determines it abuts open space. That's what the regulation says. And that's where the R3 fits in. But what you're gonna do is when you get the parcels of land, the fact that you've got to take 30% off, if your developable parcel is gonna have a 75 foot, in the R3 zone, you're going to be left with nothing. So this, basically, the way it's written, and mistakes can be made, the way it's written, it eliminates pretty much the DRD in any R3 zone, which then says to the developer, if they want to get the money, just go now to your Schedule A and build anything from 4 plexes to, which can, if it were R3, which could be done here, 4 plexes to 12 plexes, which is what it contains in your regulation by special exception.
There's specific language in the DRD under section 3510 to set back from track perimeter. There's a whole paragraph in there. So there's definitely a little bit of investigation and clarification for sure.
How many houses as right could you get for the application?
Just
How many
26,
houses?
right?
Those were.
Yeah,
Well,
sure.
with keeping the current zone, the
Mhm.
current zone.
Yes, as right,
Without changing the zone.
Yes.
That
as
I
right.
would have to go back and get a number on. I don't have that number. Because there's not a lot of rationale to do that, because then you're basically gonna disturb the entire parcel to within 50 foot of the wetlands, or what's standard in what the Wetlands Commission has allowed in the past. We don't want to do that. The reason we wanted to, we're also in a zone, we have as much, other than the land butting to open space, we have just as much land butting to R4 as we do R3 and R2. The R1 parcel, we'd like to basically give that one back and not develop it. So the reason we ended up with the DRD application or a suggestion for it is because that's the way we're led by the town planner. And to me, it's still the best way to develop it. It allows us to only solely come off of Constitution Boulevard. We're going to be able to give a better buffer to the neighboring houses no matter what, because we're not going to be going through their neighborhood. If not, we're going to be coming, we have a couple different spurs to come in to develop it, R3, R2, and R1.
Well, the thing is, you have all good intentions,
Yes.
but this is a change that would affect
Other
whole city.
pieces.
Well,
so.
but I think that's the reason why Dominic explained the fact that if the buffer was left up to the commission,
Mhm,
the commission can determine, for example, on the left side, we're already butting to open space.
mhm.
Is there a rationale to have an additional 75 foot to be open
If
space?
there's nothing there, people can come in and say, there's nothing in your regs.
Oh.
Zero.
No,
No, because your regs,
No,
it's
you're
not the way the
completely
regs
wrong.
are read.
You're
Special
asking
exception.
to take this out completely.
in a special exception, you have the right to impose the buffer. It's in the DRD. You have the right to determine what is appropriate for that area. That's your discretion on the special
So tell
exception.
me, if Tony Panico and Alex led you to this road, why did you not take this road the first time around when they were still involved?
Because originally,
Originally,
what we were told is we don't want you coming off of Constitution Boulevard. I'm thinking, why would you not want to come off Constitution Boulevard? And then finally, what happened is after we drew plans that didn't come off of Constitution Boulevard, that's when we got everybody up in arms because we were coming through Sunset. And then we were told after, well, why wouldn't you just come? What's Constitution Boulevard there for if you're not going to put a road off it? It's the last parcel that's undeveloped, basically, on Constitution Boulevard. And it's a main thoroughfare. It would make more sense to have traffic come out of Constitution Boulevard than through any other neighborhood.
so
Why would, and then that's when we were kind of taken aback. Before we withdrew, that's when we were told that, why, you should be coming off of Constitution Boulevard. We always wanted to come off of Constitution Boulevard.
So we went back to the drawing board and the drawing board evolved, okay, if you got the zone change, how can we cluster the house to preserve the open space to get open space? The two ways were under the existing zoning, which is a special exception. So if we did the existing zoning and for a special exception, you would be imposing as part of your special exception buffers to protect adjacent property owners. That's the way it would be. That's existing, and we were doing attached units similar to what was done on River Road.
Not a special exception. You're looking for a DRD.
DRD is the approval of a DRD is a special exception. It's a public hearing. you get an approval by a special exception.
Right,
It's not
so
a matter,
it's like a PDD, except
no, it's like a special,
it's got parameters.
no, in other words, you have a set of
It
regulations.
needs to do
The
something.
application vehicle is a special exception under the DRD.
Maybe I could ask Attorney Tito, so do you have any particular comments on this special exception versus?
Dominic is right. It's a special exception application. You have all of your regulations written for your DRD.
Mhm.
It's essentially an administrative review to see what's there. And certain of those regulations are discretionary.
Okay, thank you.
And the 75-foot part, is that discretionary?
No.
No. That's what it's up to.
Well, that's 70, in all fairness, that 75-foot barely works in an R1 zone. It'll never work in an
Did
R.
you speak against it in the public hearing?
I didn't even know what was happening in the public hearing.
Oh.
I wasn't paying
Getting to
attention to that. in
notice
the
You're a
public-
developer.
No, I wasn't. It wasn't a,
I mean,
well, I didn't even realize the impact.
I
First of all,
mean, to be very frank, in discussions I had with Tony when he was going through it, I said, it's not gonna be successful. DRD is not gonna be successful. Because part of the reason the DRD was done was that people were using, at that time, people were using the PDD.
Right,
In a thing. So
Exactly.
the problem is that the PRD did not generate a sufficient enough bonus to developers to be able to make the sacrifices to go in and do the.
but it wasn't
cluster.
intended to. It wasn't intended to be a widespread. Let's put everything together and use this to get more housing in. That was never the intention.
No, it was
It was
intended,
a way to stop using the PDDs for residential, but because the PRD was not, I think it was the acreage, there was,
no, the
a lot of
PRD did not have sufficient enough multipliers to increase density for the applicant.
Right.
So the DRD was going to accomplish two things. It was going to, by shrinking the lot size, and especially in areas that did not have sewer and water, there would be a little bit, because of the sewer, the septic technology had advanced. You'd be able to have smaller lots, you'd be able to increase your density, but then it was going to be tied to the open space because the conservation resource subdivision was not being used at all either. So it was an effort to do both things, try to address issues with open space, which is why in the regulations, if you look at the regulations, you could actually vary the lot size from 10 acres down. That is permitted, and this isn't 10 acres, right?
no, it's,
Yeah,
it's-
you
it's
can
not
vary the
that-
lot size if it abuts open space. That's in your DRD reg as it exists right now. So that would allow a parcel like this to go into it. That was the whole point. Increase open space connectivity, increase open space and increase density.
Well, and the added benefit to the town is it's a private road,
Mhm.
which the towns never have to plow or maintain. So it was kind of a pretty good balance, I think, for the developer and the town. And it gives them 30% open space where they're not required to, where they would have been required to 10%, and they can cut, property line to property line normally. So then you would get a buffer.
So
You know,
let me
what you're
read-
saying sounds nice for this particular situation. I guess the other things, the consideration, we have to
Oh, I
we have to
understand.
think
Oh, I
about
understand
the
that.
whole implication of other properties. And I don't think we can do that very quickly or easily, really.
We weren't expecting an answer tonight.
Yeah.
Yeah. So let me read that 3510 that I mentioned before. It's not that long. It's a setback from track perimeter. Additional setbacks may be required where the perimeter of the original track abuts streets and other private, non-open space areas. The intent of the setback is to provide appropriate visual protection where needed. The commission may require designation of non-access restrictions along existing streets where deemed necessary. That said setback area shall provide natural vegetative buffering or be appropriately landscaped with planting materials as requested and approved by the commission. to tell you the truth, at the beginning of the sentence, it's a little,
Iffy.
it's saying, no, it's saying additional setbacks may shall. So I think there was a
Right.
typo there as to, is it additional
May or
setbacks
shall?
may be required or additional setbacks shall be required?
Right.
So another problem here.
I think either way, it allows you to determine what your setback can be.
I'll defer to corporation counsel. So, all right, so if there, any questions from the commission, please present them at this time. All right, if not, we'll move to the public portion of the public hearing. And can I have that signed sheet? Okay, so we'll start off as we did before with the, any elected official of the city of Shelton who is here in the auditorium. And there's none indicated on the sign-up sheet. And if there are any elected officials of the city of Shelton that are participating remotely by Zoom or through a phone link, please raise your hand feature or dial *9.
This is me again. I'm getting kicked off. Can you, I mean,
Okay, so, Ms. Castro, any, public officials of the city of Shelton?
No.
Okay, so, then we'll move back here to the auditorium and a member of the public has signed up is Joy DeMarchis. So, Joy, why don't you take the seat over here?
Sure.
You could, give yourself a little
I
room.
can slide over.
Hi, I'm Joy DeMarchis. My family actually established Sun Meadow Unit Owners Association, which is 12212 DeMarchis Drive. I grew up working with them, got my degrees, came home. Now, for me, when I saw this proposal, it kind of hit home because when my parents had actually asked to do single family homes, they were told no. So here we are. I received a letter from Dominic Thomas. It was addressed to me, my family. I asked my neighbors, do you know anything about this? What are your thoughts? They looked at me and said they were not notified. So here we are. My neighbors look to me as a leader in this community for some reason. And the reality is, I asked them, what are your thoughts? Where do you see this going? Listen, I am a daughter of a developer. I can't look at somebody else who actually fought us and said we'd create Father Panic Village and when we were building and actually increase the neighborhood value and everybody is happy about them now, years later. So I'm not here against. Okay. Okay. At the end of the day though, I look at our community. I'm a board member of the United Way. I understand how important it is for children to have the ability to play on our streets. And they actually do. That's the beauty of our community up there. You will go down every road and see kids playing, people walking. It's amazing. It's a good thing to have. So at the end of the day, isn't that preserving? And that's when I said, well, if nobody knows, I'm going to create a change.org petition so the city can know exactly where we stand. And 250 approximately wrote in, and some of them sent you letters. And then I went to an attorney myself, because at the end of the day, I believe people's voices need to be heard. This is our community at the end of the day. These are our kids affected. And it's our quality of life. And so we sit here and I'm listening. I don't even know Dominic, and Dominic serves on the board with me, so we're not adversarial, but I don't even know what a DRD is. Okay? I have no clue. Everybody there, I mean, I've asked people to not come here tonight because you could have had a packed house here. All these people are ready to go. And so my point is this, it's not even that, Ruth, it's this. We need to let people understand what's going on, have a voice and understanding of it. Truly, Woonsocket, where we have property also butting against Dogwood, okay? you look at these areas, literally, the UPS, the refuse people, they're all backing up into our driveway because we have the longest one
You need to concentrate
Okay.
your comments
on this. Okay,
particular-
so the truth of the matter is this, when I look at this, I think it's a good idea, if you're gonna have it, go out of Constitution.
Mhm.
Don't wreck the community that we're in. You've got a lot of kids.
But this is
Yeah,
about the
but
zone,
zone
this is
change.
Zone
about the
change.
text.
Right, so.
The text change for the DRD. This is not about the application
Okay.
of what they're gonna put there.
Put there, if not,
if
okay.
this
They're
gets-
proposing removing a setback requirement from a table in the design residential development district.
Which is
That's the
explained in our
DRD.
regulations, which are online.
Okay.
Yeah.
All right, well, there we go. Sorry about that. All right, but I just wanted to come, I've talked to people, they're asking me for advice and I'm trying to provide some.
Yeah.
Without having all the knowledge, to be quite frank. I don't know what a
You're
DRD
more
is.
than welcome to call and make an appointment with
Mhm.
staff. They have hours, they'd be more than happy to sit down with you and go
Mhm.
over things, so if you have any questions in the future, take
Yep.
advantage of that. Alexandra Castro is our assistant administrator. She's available to
Okay.
any member of the public.
Yeah, because when people ask me, they think I know and I don't know all this stuff.
Yeah.
This is not my bailiwick,
Yeah.
but
While everything is
Yeah.
online, just from reading tonight, you
Yeah.
can understand it. They're complicated.
it is complicated and that's the hard part.
Yep.
Because then they'll look at me or, some others in the room and say, what does this mean? I'm like, well, I don't know, but Constitution looks good to go with that. I'm just being
This
honest.
is just about
Yeah.
moving that 75-foot setback.
Okay, well,
Okay.
all right,
All
thank
right.
you.
Is there anyone else here in the auditorium that would like to speak? Come on up, man. And just sign the sheet. Yeah. Good.
Hi, I'm Becky Douglas again. I just wanted to ask if you could put that map up again, where the wetlands are.
You just comment to the commission and the applicant responds later.
Oh.
So on the map, your question is.
Where are the
has to do with-
wetlands?
You want to,
This
okay,
is-
but this is, has to do with the
Yeah.
text change. There is, we're not talking tonight on the agenda about a particular piece of property. Okay, it's just, should our regulations be changed to allow in the DRD district a lack of.
Reduction.
A reduction or elimination of the setback,
And what is a DRD?
design development district.
Design
Residential.
residential development.
Okay. So now with the setback,
Mhm.
what exactly does that mean? Does that mean like you would put a house and then there's so many feet to the road? Is that what that
To the property
means?
line, most likely.
Well,
And that's the question we had as to where's the definition of setback from track perimeter property line? That's where there's some confusion. Where is that
Yeah,
defined? Is it track from the property line, the edge of the street? Or is it after a, wetlands is removed from it?
Okay,
So,
okay. Thanks, guys.
no, you're more than welcome to come. Just pass all that back. All right, if there's nobody else here in the auditorium, then I'll ask if there's any members of the public that are wishing to comment on this application. If you're participating via Zoom, please use Zoom's raise your hand feature. And if you're participating remotely through a phone link, please dial *9 to be identified. Ms. Castro, is there anybody participating remotely?
None showing.
Neither. Okay. All right, so Attorney Thomas,
Yeah, I
there were a
would
couple
like,
comments that you might want to respond
I
to.
would like to address because in a way, I'm going to sort of agree with Joyce DeMarchis that there is a connection between this application and some of the points she made. And if we were listening, especially as AJ was explaining, if you're developing the property as a matter of right to most effectively develop it, you would probably come off of Constitution in some cases and come through Woonsocket in the other cases. I think the thing, it is obvious, and first of all, the public hearing needs to be kept open for the benefit of the neighborhood and needs to be heard with the zone map change. So there can be a discussion and an interrelation. And hopefully, what we hope is will also be heard with the DRD special exception application. So the neighborhood can have a full understanding rather than have the unfortunate situation, which they can be, of saying, I'm sorry, we can't answer that question because we're talking only about 75-foot elimination. There is an interrelation between the three in that if the text change is not done, then the DRD in an R3 in this situation becomes impossible. And therefore, what the applicant is being told, well, you can come in for a zone map change to change it all to R3, rather than have a hodgepodge of your zones, here, and then develop it in accordance with R3. If you develop it in accordance with R3, it's a matter of right. If you develop it in accordance with R3, which has been, or R2 and R3, it's been determined because it was zoned R2 and R3 that the infrastructure supports it. So that means that in order to properly develop it, not and deal with topography and everything, access to it may be twofold from Constitution and from interior, from Woonsocket or other streets that would dogwood that would access and touch the property. So that's how you would have to develop it. I mean, unless the property owner decided not to, and that's not within the realm of possibility at this point, they are going to develop it. So while I understand you're saying, well, that's what Tony put in, so it must be right. Well, you know what? What I'm saying to you is, I think it needs to be rethought. I think when you
It's not
look
just
at
what
the.
Tony put in, it was a discussion amongst the
Right,
commission at
exactly.
that time.
And it was a discussion because
wasn't-
it was.
Tony doesn't dictate.
Right, it was focused on property. It was in the R1 zone. There was a very large parcel of property that had a lot of open space. But, and again, I wasn't involved.
It wasn't designed for one parcel.
Right,
That's, Tony went across the city looking for parcels that this could apply to.
right.
So it
Exactly.
wasn't a zone that was put
Right.
in place for one parcel.
I understand that, but in reality, if you're going to do that, you're basically eliminating all R3 parcels. If that's the decision of the commission, that's it. It's just that we need to be able also, that's why we wanted to present it into an interrelated fashion to show you that this is what would be best. And again, I stress, you are not giving up the ability to impose buffers. It's in the regulation, and 35.10 could easily be also tweaked if you felt it wanted to be tweaked to strengthen it, because 35.10 is written in such a fashion that it sounds like you can increase the buffer, but it also sounds like the way you're reading it, you can decrease the buffer depending on other factors. And that's the way it's written. It seems to be written, although there's some.
Yeah, I'm gonna go back to my original document too, because that could have just been happened as a result of the voice.
Typing in
Yeah.
and whatever they do it. But I mean, so that's our response to the questions, and we do hope you would keep it open. You would run it in connection with the other one, and we're going to hope to get the special exception in so that everybody can understand that.
Okay, I'm gonna turn to Attorney Titoso.
I have a question for you, Donna.
Yeah.
If you think that the reading of 3510 is discretionary for setbacks, track backs, whatever you want to call them, why not change the regulation just to say up to 75 feet instead of eliminating it?
Commission has the right to approve, deny, or modify. If the commission feels that's comfortable and it can allow an application that doesn't have 75 feet, that's fine. Because my application,
But you're proposing to eliminate the 75 feet.
That's
I'm
right.
saying up to 75 feet.
Again, the commission has the right, certainly that's something, if it does not prevent us from filing the application, allows us to come before the commission in that fashion. The commission has the right to approve, deny, or modify, and the commission can decide that we are going to modify the application rather than eliminating it by putting it into up to 75. Or what it could do, and one other option, is to leave it as 75 feet in the R1 zone. Leave it as up to 75 feet in R1 and R1A. And leave it at a different number, a more realistic number, when you consider that R3 is less than half the size of an R1 lot. So why wouldn't you have the buffer up to, let's say, 25 feet? And allow the discretion, do a similar percentage in lot size. These are things that we were discussing, but I mean, they were coming in here based on the discussions we had, that we would have to make changes, and the preference was to use the DRD. And I boiled it down to one change. There were other things we talked about. I boiled it down to a single change, knowing that the commission could still impose buffers.
Unfortunately, that's hearsay at this point.
I know,
And I was just gonna bring up the fact that you referenced Mr. Panico and Mr. Rossetti, but neither of them are with us any longer.
Right.
So if they had been here
They-
tonight, they could have
yeah.
explained their thought process, but.
Yeah, their thought process was, as AJ explained, was to use the DRD. We did not discuss changes. We discussed what issues we had with the DRD.
Mhm.
And we resolved a lot of them in the discussion. This was the one that was left.
Attorney Tito, so you have any other comments?
Up to 75 feet against an R3 zone would still give the board discretion.
Yeah.
Then we could look at the actual plan.
Right.
See
Yeah, more
if it
workable.
fits. Yeah.
I would agree to keep this hearing open because I want to go back and look
Mhm.
at this without having a full recollection of the discussion, et cetera, of why this 75 feet, which is almost double, triple what some of those other setbacks are. There was a reason for it.
Yep.
So I want to research that first.
So if there's any.
Not that I
other
like to make
comments.
any kind of text change for a
Yeah.
specific project. Just don't like that concept.
Okay, so unless there are any other comments, is there a motion on this particular application?
Make a motion to keep the public hearing open.
Okay, there's a motion to continue the public hearing for application 2418 from Commissioner Parkins. Is there a second?
Second that.
And Commissioner Cristiano has seconded, and on the motion to continue, I'll do a roll call. Commissioner Motto?
Aye.
Commissioner Tiki?
Aye.
Commissioner Cristiano?
Aye.
Commissioner Kelly?
Aye.
Commissioner Parkins? And chair votes aye. Motion is passed by a vote 6-0. So the continuation of this public hearing will be on the agenda of an upcoming meeting, and the public will be able to present comments on any new material that may be submitted by the applicant after this evening. I'm sorry? Yeah, as well as the commission. So, all right, we'll move on to the next agenda item, which is okay, so this is, old business now, and we're doing, first item is ZBO 24-41. It's an application for certificate of zoning compliance for rodeo cannabis, 504 Bridgeport Avenue. It's directed by commission. Staff has prepared a resolution for review and discussion, and I recognize Attorney Frantioso, our corporation counsel, to present the resolution.
Read it.
Yeah, go right ahead. If you have any lead in or anything.
Can everybody hear me?
Yes.
The applicant, Attorney Dominic Thomas, represents PVG LLC, doing business as Rodeo Cannabis Company. The application 24-08 proposes to open 2,000 square foot cannabis dispensary based on state of Connecticut statutes and regulations. The application originally and specifically included a pickup window. This application, number 24-08, was initially filed with the Shelton Planning and Zoning Commission Administrative Office on April 22nd, 2024. Under section 34.14 of the Shelton zoning regulations, if a requested modification of a PDD is minor in nature, the plans may, emphasis added, be approved administratively by the commission. A modification or adjustment of a PDD is considered minor if it does not materially change the nature, scope, or intensity of the PDD. This application was filed shortly after the commission's moratorium on the sale of cannabis expired and days before the time the Shelton Board of Aldermen voted to ban cannabis sales in Shelton. A majority of the commission did not consider the modification application perfunctory in nature, despite the applicant's claim that a cannabis dispensary was merely a state of Connecticut sanctioned new retail outlet allowed within the previously approved PDD. The commission, using its authorized discretion, chose to review the application at various meetings and hold a public hearing. During the process, on May 10th, 2024, the applicant modified its statement of use by abandoning the assertion that the intended use was very similar to that of a previous use, to wit, a bank branch with a drive-through teller. The final revised statement of use presented by the applicant was that the sale of cannabis should be allowed under the previously approved PDD use, that being a store where goods were sold or a service is rendered primarily at retail. At various dates while its application 24-08 was before the board, the applicant, inter alia, submitted the following: a configuration of the subject PDD showing its proximity and traffic pattern in relation to an abutting PDD number 41, which together represented Crown Point Center. Site plan of the interior of the cannabis dispensary. A schematic depiction of 504 Bridgeport Avenue, which is a 6,686 square foot building. The document depicted approximately 25 parking spaces in the front of the building and 10 more behind it. It also illustrated the configuration of the roadway by which customers would enter, access, and depart the primary parking areas of the cannabis shop. Lastly, it noted the location of 6 tandem parking spaces in place of the drive-through lane. Generic calculations not specific to the location that peak hours would generate 38 trips to or from the cannabis shop, necessitating a need for 6 spaces for every 1,000 square feet of space. And written comment by the applicant that other uses such as convenience stores and coffee shops have a peak hour higher than that of a cannabis shop. During the public hearings, the majority of speakers and letters urged the commission not to modify the PDD to allow the dispensary. Members of the Board of Aldermen, which had passed the ordinance prohibiting dispensaries in Shelton, spoke against the change. During these hearings, the information was provided that other business tenants at 504 were a coffee shop, a smoke shop / convenience store, and a beautician. Having closed the hearing, the commission deliberated as to whether to modify the PDD. Discretionary authority of the commission. The Shelton zoning regulations afford the commission broad discretionary authority as to PDD number 48 and the buildings within it. The commission may modify the PDD after public hearing if there is no material change in any of the basic elements of the plan. The PDD text, when initially approved in 2004, provided that, quote, the following uses shall be the only uses permitted within the planned development district. And for the audience's benefit, you can't see this. Oh, you can. I didn't realize it was up there. We're only quoting from 2 sections here. Stores and other buildings and structures where goods are sold or services is rendered primarily at retail, and a banking facility with a drive-through for a teller and ATM transactions. Density of parking, intensity of traffic. Although the applicant opines that there are sufficient spaces available to visitors to this PDD, the parking spaces within physical proximity to the 6,686 square foot building known as 504, are at best 30 to 32, which includes the 10 spaces in the back of the building. There are 20 to 22 spaces in front of the building. This variability is due to some spaces being handicap designated and the other being situated in what seems to be the travel portion of the traffic lane, which abuts the south side of the building and the 6 tandem lane parking spaces reserved for employees. Customers visiting the dispensary will most likely attempt to park in the front of 504 after turning right from the one-way entranceway located on the north side of the building. Customers of the contiguous smoke shop, beauty shop, and coffee shop will probably also make such a turn for the parking spaces. The map and formula of the applicant indicates a peak hour for the dispensary, and at least 2 of these 3 existing businesses, the amount of trips will be in excess of 100. That's 3 times 38 trips equals 114 trips. When the beauty salon is added in, the number of trips and vehicles searching or leaving spaces would be well over 125 in and out. As already noted, the number of spaces in front of the building that these cars would be moving into or out of is 20 to 22. The commission is concerned that this circumstance is a safety hazard for customers patronizing the existing tenants. This is not the type of use originally planned for the PDD, nor one the commission is inclined to allow through modification of the PDD. The switch of the use at 504 brings a material change in the basic elements of the plan. When the option of the parking in the remaining 10 spaces at the rear of the building is considered, the traffic congestion and safety concern of the 125 trips remains. Once cars have turned right into the parking lot to search for a space, if all are full, a driver would logically drive east via the traffic lane located on the south side of 504 toward the back parking spaces. If the driver is able to find the back parking space, she or he then must either walk back to the front via the previously traveled lane, which has 2-way traffic, or she or he could venture to the south and turn west into the 1-way traffic lane, which directs traffic east past the building 504. All this venture parking or walking is necessary because there's only one front entrance to the dispensary. Yet another complication to this parking and traffic peak hour circumstance involves the 6 tandem employee parking spaces gerrymandered into what had been the drive-through lane of the bank. Having abandoned the lane, the applicant identifies 6 tandem or stacked parking spaces. At some point in time, the employees must leave the parking lot. Whether they exit from the back or the front of the lane, they will drive directly into travel lanes surrounding the building. These travel ways are narrow and, as calculated above, will be teeming with customers looking for spaces. Finally, the location of the proposed cannabis dispensary is one of the most heavily traveled roadways in Shelton. This, coupled with its being, if approved, the only cannabis dispensary in Shelton, would add to the traffic intensity, parking congestion, and safety concerns already noted as endemic to the configuration of the building, traffic patterns, and parking layout. Schedule 1 drug. As noted above, the commission has substantial discretion and authority when approving uses to be allowed in a PDD. In 2004, when it originally approved the use for 504, the commission contemplated a bank with a customary drive-through and perhaps a retail store selling foodstuffs and morning sandwiches. Retail sales did not mean dispensaries of federally illegal Schedule 1 drugs. At the PDD's inception, the Drug Enforcement Agency of the United States considered cannabis to be a Schedule 1 and illegal. The commission agreed then and agrees now and is not inclined nor convinced that including a marijuana dispensary in PDD 48 is a minor modification of the district. This too would affect a material change in the originally approved PDD. Therefore, based on its review of the proposal, its knowledge of the site, and its general area, subject to the considerations outlined in the report, I'll turn it over to you, Madam Chair.
Thank you. So is there a motion on this particular resolution?
I'll make a motion to.
Are we discussing it or
Accept
no?
for discussion? Food for discussion?
Sure, if you would like to have a discussion, if you'd like to make a motion for discussion. Commissioner Parkins, is there a second?
I'll second that.
Okay, so there's a motion to discuss made by Commissioner Parkins, seconded by Commissioner Amato. All those in favor, please signify by saying aye. Aye.
Aye.
Any opposed? Any abstentions? Let the record show that the motion was to discuss was approved by a vote of 6-0, and no commissioner voted nay or abstain. So the floor is open for discussion. Is there anyone in particular who wants to present any comments?
I'll just say, I understand this is a different use than what we've ever experienced, and there are legitimate concerns about traffic and parking and all of that, but I don't know what kind of, based on this kind of analysis, I don't know what kind of business would be allowed into that empty space that you could say there would not be a parking concern or a traffic concern. So I'm not, I don't think the rationale here is very strong. So
Okay, thank you, Commissioner Amato. Anybody else?
Yeah, this is Commissioner Ticky. I think we know where each of us stand on this because we've discussed it so much, but I take issue with the way some of this was worded based on what we had heard from the applicant and with the public. So I think we had heard how they were going to be processing people through, and I think that this paints a little bit of a different story. And I agree with Commissioner Amato's comments as well.
Thank you, Commissioner Ticky. Commissioner Parkins, you were about to say something?
I think it actually accounts the discussion.
It accurately?
Yes.
Okay. That's the word.
Actually.
Okay. All right. Commissioner Cristiano, did you have any comments?
I'd like to say that, I think the safety points noted here regarding the traffic flow are legitimate. The impact to the adjoining business located in that particular plaza area are significant. It does not meet the original agreement of what this particular building was designed for. It was a bank. The drive-through was for a bank. It's not the same type of business. No, yeah.
Okay, Commissioner Kelly, you're here remotely. Did you have any particular comments?
No, I think everyone has said what they were, what they thought, and I think we said it when we took a vote before. I'm fine with it.
Okay. All right, I particularly would agree with Commissioner Kelly. We had a discussion and there was a consensus. It wasn't 100%, but the majority did feel that this was an application where the minor modification should be denied. So if there are no other comments, is there a motion on the resolution?
Make a motion to accept the resolution as presented.
Mr. Commissioner Kelly, I'll second that.
All right, so on the resolution, Commissioners Cristiano and Kelly, the wording, are you in agreement with the wording that says it's a motion to deny the minor modification to PDD number 48?
Correct, as presented.
Okay,
Yes.
all right.
Yes.
That's the wording that was presented. So there's a motion made by Commissioner Cristiano and seconded by Commissioner Kelly. So to deny the minor modification to PDD 48. So on a roll call vote, Commissioner Parkins?
Aye.
Commissioner Kelly?
Aye.
Commissioner Cristiano?
Aye.
Commissioner Amato?
no,
Nay. Commissioner Ticky?
Nay.
That's a nay.
Correct.
And chair votes aye. Motion to deny the minor modification to PDD number 48 is passed by a vote of 4-2. All right, the final and last item on the agenda is application 24. And which is PDD number 91, Dominic Thomas for Fountain Square LLC at 801 Bridgeport Avenue, Assessors Map 28, Lot 18, for a major modification to PDD, initial concept development plans, and amendment to the statement of uses and standards for removal of the proposed office building and hotel, replacing it with a 13,800 more or less square foot specialty grocery store and a 100-unit residential apartment building. This application was accepted for review by the commission on July 10th. On August 14th, a public hearing was held. The floor is now open for discussion on this application. Is there any commissioner who has anything?
I'll start.
Go ahead, Commissioner Mono.
All right, so there are some things about this that I like, and I'll have to say, I'm not one of those people who's against housing on Bridgeport Avenue in all cases. But I do have an issue with the number of apartments and the parking ratio. Even if this were on the same level as other parts of the development, it's up a flight and a half, I think, from other areas where people could park. I think I'd be more in favor of this if there were maybe 25% less apartments. Or knock off a floor. That's what I think.
Okay. Anybody else?
Not here.
Yes, go ahead, Commissioner Cristiano.
Just to agree, I believe the density of that upper pad is a factor here. The grocery store will generate a significant amount of traffic flow and parking. The proposed 100 units will generate a significant amount of traffic flow and parking. The parking ratio, I thought, was very tight up there. There was no visitor parking. There was not, in other developments we've seen presented to this commission were studio and one-bedroom apartments. This particular development presented two-bedroom apartments, which in my opinion yielded to multiple car units. The ratios again were very tight. So in addition to the vehicular traffic pattern, 100-unit apartment complex would lend to a tremendous amount of foot traffic. And the only way to get foot traffic is from the upper slab is to walk down the set of stairs. My concern is this is not a public access where the city buses can get in there. I mentioned this before. For students to get down all the way to Bridgeport Avenue, I think is a significant safety concern. I think it's unrealistic to assume that parents are going to be driving their children down to Bridgeport Avenue, which is essentially at the bottom of that main entrance or the Parrot Drive entrance, which would create other traffic concerns as parents wait for buses to come in the morning in a already congested traffic area.
Okay, thank you, Commissioner Cristiano. Commissioner Perkins or Commissioner Kelly?
I agree with Commissioner Cristiano. I see no place for an apartment complex within that complex. As far as traffic, safety, school children, so on and so forth, it just doesn't fit.
Okay, Commissioner Zicki, did you have any comments?
I don't think I attended this meeting in person, but I did watch it back, and I agree. I think, as it's been said, because we've talked about this development so many times, it continues to be disappointing that what originally came through isn't what we have now. And I drove through it and drive through it regularly if I'm going to any of the stores up there, and it's hard to imagine how that could fit, let alone 100 units of apartments there. I have a hard time seeing how it would work with the traffic and with people walking around in a plaza that's being built out and is going to be built out fully.
Okay, thank you, Commissioner Dickey. I would just like to reiterate what we've said in the past, that we have felt that apartment building on this particular site is not at all desirable. And it is a shame that the applicant chose to submit this particular application for two different uses and two distinct different uses. And I would not be in favor of moving forward in a positive manner with this particular application. Any further comments from the commission?
I would just agree with most of everything that's been said. While I think the addition of a boutique grocery store could be possibly a nice addition, I don't agree with the apartments being tied to it.
Mhm.
So I'm not in favor.
Okay. All right, well, if there aren't any further comments, it appears that the consensus of the commission is for denial of this particular application, and staff is directed to prepare an unfavorable resolution for action by the commission at an upcoming meeting. And seeing that there's no other item on the agenda, the chair declares this evening's meeting is adjourned as of 8:58 p.m. Thank you, everyone, and good night.
Yeah.
Good night.
Pretty good. Why not?